California evidence. Section 500, 600, 601, 603 through 606. Section 500. Party who has the burden of proof. Except as otherwise provided by law, the party has the burden of proof as to each fact, the existence or non-existence of which is essential to the claim for relief or defense that he is asserting. Is this allocation of the burden of proof helpful to proceeding to distribute the illustrative question provided in the introduction of this chapter, which I add as community property in California. Chapter 4, evidentiary presumptions in California community property law. Section 600, presumption and inference defined. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. An inference is a deduction of fact that may logically and reasonably be drawn from another group of facts found or otherwise established in action. So we learn the definition of both presumption and inference. Comment, Assembly Committee on Judiciary. Assumptions are not evidence, but are conclusions that the law requires to be drawn in the absence of a sufficient contrary showing when some other fact is proved or otherwise established in the action. Section 601, classification of presumptions. Presumption is either conclusive or rebuttable. Every rebuttable presumption is either a presumption affecting the burden of producing evidence or B, a presumption affecting the burden of proof. So conclusive or rebuttable. Comment, Law Revision Commission. Under existing law, some presumptions are conclusive. The court or jury is required to find the existence of the presumed fact, regardless of the strength of the opposite evidence. Under existing law, too, all presumptions that are not conclusive are rebuttable presumptions. For several decades, courts and legal scholars have wrangled over the purpose and function of presumptions. The view espoused by Professors Thayer in Preliminary Treatise on Evidence 313 to 352 of 1898 and Wigmore, 9 Wigmore Evidence Sections 2485 to 2491, 3rd edition, 1940, accepted by most courts, and adopted by the American Law Institute's Model Code of Evidence, that the presumption is a preliminary assumption of fact that disappears from the case upon the introduction of evidence sufficient to sustain a finding of the non-existence of the presumed fact. In Professor Thayer's view, a presumption merely reflects the judicial determination that the same conclusionary fact exists so frequently when the preliminary fact exists that once the preliminary fact is established, proof of the conclusionary fact must be dispensed with, unless there is actually some contrary evidence. Many facts and groups of facts often recur, and when a body of men with a continuous tradition has carried for the same length of time this process of reasoning upon facts that often repeat themselves, they cut short the process that lay down a rule. To such facts they affix, by a general declaration, the character and operation which common experience has assigned to them. And that's from Thayer's Preliminary Treatise on Evidence, 326 from 1898. Professors Morgan and McCormick argue that a presumption should shift the burden of proof to the adverse party. Morgan, Some Problems of Proof from 1956. McCormick, Evidence, Section 317 at 671 to 672 from 1954. They believe that presumptions are created for reasons of policy and argue that If the policy underlying a presumption is of sufficient weight to require a finding of the presumed fact when there is no contrary evidence, it should be of sufficient weight to require a finding when the mind of the trier of facts is in equilibrium. The classification of presumptions in the evidence code is based on a third view suggested by Professor Bolin in 1920. Bolin, the effect of rebutable presumptions of law upon the burden of proof. 68 UPAL Review 307 from 1920. Underlying the presumptions provisions of the evidence code is the conclusion that the Thayer view is correct as to some presumptions, but that the Morgan view is right as to others. The fact is that presumptions are created for a variety of reasons, and no single theory or rationale of presumptions can deal adequately with all of them. Hence, the evidence code classifies all rebutable presumptions as either presumptions affecting the burden of producing evidence, essentially Thayer presumptions, or two, presumptions affecting the burden of proof, essentially Morgan presumptions. So that essentially part is kind of what they're also known as. Articles 3 and 4, sections 630 to 668 classify many presumptions found in California law, but many other presumptions, both statutory and common law, must await classification by the courts in accordance with the criteria in section 603 and 605. The classification scheme contained in the evidence code follows a distinction that appears in the California cases. Thus, for example, the courts have at times held that presumptions do not affect the burden of proof, and at other times the courts have held that with certain presumptions do affect the burden of proof. Estate of Walker, 1919, this is California. Clear and satisfactory proof required to overcome presumption of legitimacy. The cases have not, however, explicitly recognized the distinction, nor have they applied it consistently. The evidence code clarifies the law relating to presumptions by identifying the distinguishing factors, and it provides a measure of certainty by classifying a number of specific presumptions. Section 603, presumption affecting the burden of producing evidence, defined. The presumption affecting the burden of producing evidence is a presumption established to implement no public policy other than to facilitate the determination of the particular action in which the presumption is applied. Common law, Law Revision Commission. Section 603 describes those presumptions that are not based on any public policy extrinsic to the action in which they are invoked. These presumptions are designed to dispense with unnecessary proof of facts that are likely to be true if not disputed. Typically, some presumptions are based on an underlying logical inference. In some cases, the presumed fact is so likely to be true and so likely to be disputed that the law requires it to be assumed in the absence of contrary evidence. In other cases, evidence of the non-existence of the presumed fact, if there is any, is so much more readily available to the party against whom the presumption operates that he is not permitted to argue that the presumed fact does not exist unless he is willing to produce such evidence. In such other cases, there may be no direct evidence of the existence or non-existence of the presumed fact. But because the case must be decided, the law requires a determination that the presumed fact exists in light of common experience, indicating that it usually exists in such cases. Typical of such presumptions are the presumption that a mailed letter was received, section 641, and presumptions relating to the authenticity of documents, section 643 through 645. Section 604, effect of presumption affecting burden of producing evidence. The effect of a presumption affecting the burden of producing evidence is to require the trier of fact to assume the existence of the presumed fact until evidence is introduced which would support a finding of its non-existence, in which case the trier of fact shall determine the existence or non-existence of the presumed fact from the evidence without regard to the presumption. Nothing in this section shall be construed to prevent the drawing of any inference that may be appropriate. Comment, Assembly Committee on Judiciary. Section 604 describes the manner in which the presumption affecting the burden of producing evidence operates. Such a presumption is merely a preliminary assumption in the absence of contrary evidence. For example, evidence sufficient to sustain a finding of the non-existence of the presumed fact. If contrary evidence is introduced, the trier of fact must weigh the inferences arising from the facts that give rise to the presumption against the contrary evidence and resolve the conflict. For example, if a party proves that a letter was mailed, the trier of fact is required to find that the letter was received in the absence of any believable contrary evidence. However, if the adverse party denies receipt, the presumption is gone from the case. The trier of fact must then weigh the denial of receipt against the inference of receipt arising from proof of mailing and decide whether or not the letter was received. Section 605, presumption affecting the burden of proof defined. A presumption affecting the burden of proof is a presumption established to implement some public policy other than to facilitate the determination of the particular action in which the presumption is applied, such as the policy in favor of establishment of a parent and child relationship, the validity of marriage, the stability of titles to property, or the security of those who entrust themselves or their property to the administration of others. Comment, Law Revision Commission. Section 605 describes a presumption affecting the burden of proof. Such presumptions are established in order to carry out or to effectuate some public policy other than in addition to the policy of facilitating the trial of actions. Frequently, presumptions affecting the burden of proof are designed to facilitate determination in the action in which they are applied. Superficially, therefore, such presumptions may appear merely to the presumptions affecting the burden of producing evidence. What makes a presumption one affecting the burden of proof is the fact that there is always some further reason of policy for the establishment of the presumption. In the existence of this further basis in policy that distinguishes a presumption affecting the burden of proof from a presumption affecting the burden of producing evidence. For example, the presumption of death from 7 years absence, section 667. The presumption of death, exists in part to facilitate the disposition of actions by supplying a rule of thumb to govern certain cases in which there is likely to be no direct evidence of the presumed fact. But the policy in favor of distributing estates, of settling titles, and of permitting life to proceed normally at some time prior to the expiration of the absentee's normal life expectancy, perhaps 30 or 40 years, that underlies the presumption indicates that it should be a presumption affecting the burden of proof. Frequently, too, a presumption affecting the burden of proof will have an underlying basis in probability and logical inference. For example, the presumption of the validity of a ceremonial marriage may be based in part on the probability that most marriages are valid. However, an underlying logical inference is not essential. In fact, the lack of an underlying inference is a strong indication that the presumption affects the burden of proof. Only the needs of public policy can justify the direction of a particular assumption that is not warranted by the application of probability and common experience to the known facts. Thus, the total lack of any inference underlying the presumption of the negligence of an employer that arises from his failure to secure the payment of workmen's compensation, Labor Code, Section 3708, is a clear indication that the presumption is based on public policy and affects the burden of proof. Similarly, the fact that the presumption of death from 7 years absence may conflict directly with the logical inference that life continues for its normal expectancy is an indication that the presumption is based on public policy and hence affects the burden of proof. Lastly, Section 606, effective presumption affecting with an A, burden of proof. The effect with an E of a presumption affecting with an A, the burden of proof, is to impose upon the party against whom it operates the burden of proof as to the non-existence of the presumed fact. Comment, Assembly Committee on Judiciary. Section 606 describes the manner in which a presumption affecting the burden of proof operates. In the ordinary case, the party against whom it is invoked will have the burden of proving the non-existence of the presumed fact by a preponderance of the evidence. Certain presumptions affecting the burden of proof may be overcome only by clear and convincing proof. When such a God. When such a I like these standards. Preponderance of the evidence, and clear and convincing proof. So, in the ordinary case, the party against whom it is invoked will have the burden of proving the non-existence of the presumed fact by a preponderance of evidence. Certain presumptions affecting the burden of proof may be overcome by clear and convincing proof. When such presumption is relied on, the party against whom the presumption operates will have a heavier burden of proof and will be required to persuade the trier of fact of the non-existence of the presumed fact by proof sufficiently strong to command the unhesitating assent of every reasonable mind. That's from Sheehan v. Sullivan in California, 1899. Notes and questions to this section that are posited by the author Blumberg. As the California Evidence Code and comments suggest, legal presumptions generally serve one or more of three distinct functions. They reflect probability, the party's relative access to the evidence, and the strength of the public interest in finding one way rather than the other. Considerations of probability and access to the evidence generate burdens affecting the production of evidence. Public policy considerations generate presumptions affecting the burden of proof and rules concerning the quantum of proof necessary to overcome those presumptions. Compelling public policy concerns have on occasion given rise to irrefutable presumptions. For example, see Cousier v. Silver of California, 1960, discussing a former California statute providing that the issue of a wife cohabitating with her husband who is not impotent is indisputably presumed to be legitimate. This provision, now weakened, is embodied in California Family Code sections 75, 40 through 41 and 41. Does an irrefutable presumption of paternity that is contrary to a fact now conclusively ascertainable by genetic test violate a human's procedural or substantive due process rights? See Marriage of Stephen and Sharon B. from 1981, Michelle W. and Ronald W. 1985. And the second note here is the California Evidence Code does not specifically address community property presumptions and hence does not specify whether they are Section 603 or 605 presumptions, nor does the California Family Code compare the Uniform Marital Property Act, which provides presumption or presumed fact means the imposition on the person whom the presumption or presumed fact is directed of the burden of proving that the non-existence of the presumed fact is more probable than its existence. And that's a citation from the Uniform Marital Property Act, Section 114, 9A, ULA 112, 1998.